yeah, sure, you won't have the emissions from the plant. I think that is just taking it on up to again, a fundamentally different level in just the same way as ground.
Do you have another
precedents?
Thank you.
Thank you.
Thank you, Counsel. General Preligar, why don't we take a 5-minute break? General Preligar?
Mr. Chief Justice, and may it please the court. This case is not justiciable, and petitioners are wrong on the merits in any event. On justiciability, the D.C. Circuit's judgment leaves no EPA rule in effect. The agency action challenged here wasn't the Clean Power Plan, it was the decision to replace it with the ACE rule. The D.C. Circuit vacated ACE, but chose not to reinstate the CPP, so no federal regulation will occur until EPA completes its upcoming rulemaking. Petitioners aren't harmed by the status quo and can't establish Article 3 injury from the D.C. Circuit's judgment. Instead, what they seek from this court is a decision to constrain EPA's authority in the upcoming rulemaking. That is the very definition of an advisory opinion, which the court should decline to issue. If the court reaches the merits, it should affirm. No one seriously defends the ACE rule's view that the statute restricts states and power plants to inside the fence line measure. That restriction is unprecedented and would threaten to disrupt an industry that has long relied on measures like trading and averaging to reduce emissions in the most cost-effective way. Nor does the statute limit EPA to inside the fence line measures in identifying the best system of emission reduction. Petitioners claim that interpretation is necessary to prevent the EPA from restructuring the entire industry or shutting down all coal plants. We agree that EPA cannot do those things, but that's because of the express constraints that Congress included in the statute. Among other things, the system has to be adequately demonstrated. It has to be of reasonable cost. It can't threaten the reliability of the energy grid. And critically, it must be focused on cleaner production, not on reducing overall levels of production. Finally, petitioners are wrong to say that this case implicates a major question. For all their criticisms of the CPP, we know that it wouldn't have had major consequences. The industry achieved the CPP's emission limits a decade ahead of schedule and in the absence of any federal regulation. Given that reality, petitioners ask the court to focus on the nature of the statute in the abstract, not on the particular effects of any particular regulation. But that is never how this court has looked at major questions, and it just reinforces that petitioners are seeking an advisory opinion here. I welcome the court's questions.
Would you kindly say a bit more about your statement that the court did not, the D.C. Circuit did not reinstate the CCP?
Yes, of course,
or
Justice.
CPP?
Of course, Justice Thomas. So at the time that the case was pending in the D.C. Circuit, I think there was a live question about what EPA's rule would be. Was it going to be the CPP or was it going to be ACE? But when the D.C. Circuit issued its judgment and vacated the ACE rule, it did not reinstate the CPP. And I think that was for good reason. There were really three key facts that had changed on the ground that I think prompted the D.C. Circuit to determine that that was the appropriate remedy here. The first thing I would emphasize is that the CPP had never taken effect, so it had never altered the status quo or subjected petitioners to any further regulation. And then second, the industry had very much undergone tremendous changes, and so the CPP was totally obsolete. The emission limits had been satisfied, and the compliance deadlines for submitting state plans had come and gone. And then the third fact I would point to is that EPA had made clear that if the ACE rule were invalid, it was going to go back to the drawing board and do a new rulemaking, which is what it's currently doing. It did not seek to breathe new life into the CPP, and I think therefore the D.C. Circuit recognized that the CPP was gone and it wasn't coming back.
Oh, I don't understand. I mean, I must be wrong. So just tell me I'm wrong. I thought that the agency, EPA, said we're getting rid of the CPP. And the reason we're getting rid of it is because our interpretation of the law is ACE. Is that right?
That's correct.
Okay, so then they go to the D.C. Circuit, and the D.C. Circuit says, no, your interpretation of ACE is wrong. Well, if their reason for getting rid of the CPP is ACE, and if ACE is wrong, and then you send it back to the EPA, why isn't CPP back? Because they've never had any good reason for getting rid of it.
Because there's a well-developed body of administrative law that speaks precisely to that issue about what the effects will be when a rule is invalid and vacated. And it's not the case that the prior regulatory regime always and invariably springs back into existence. Instead, the D.C. Circuit has made clear that it resolves that on a case-by-case basis, and sometimes it's appropriate to prior rule back into effect.
Okay, and what did they say here?
And here we think the DC Circuit's judgment
Did it say that?
notably did not put the CPP back into effect. It only vacated ACE. And then the DC Circuit confirmed that that was the best reading of its judgment when it issued the partial stay of the mandate to make clear that in the interim until EPA conducts its
Okay,
rule,
so in other words, they said, EPA, you're wrong about ACE. But EPA, even though that was the only reason you gave for getting rid of CPP, CPP is not back.
yes, that's how we
If
interpret
I
the
read
DC
that
Circuit's
interpretation,
judgment.
now if I don't agree with that, I don't know if I, I have to go with that, but I'll go read that, and then suppose I don't agree with you, I think, oh God, you're going to send it back, CPP will back, and you are in the midst of a new rulemaking. So how do you get rid of CPP? I mean, one, you have the power not to prosecute. You're pretty broad power, but that's point by point. Two, you have a power to suspend things for good cause. You know, the good cause, you don't have to go. You wouldn't have to get rid of CPP via rulemaking because you can do it quickly through good cause. Is there anything else you have?
Well, Justice Breyer, I want to resist the premise in the first place that the CPP could possibly come back into effect. Among other things, all of the key compliance deadlines for the submission of state plans have come and gone. So EPA needs to do a rulemaking regardless, as your question suggested, in order to even sensibly try to implement the CPP. But it said just the opposite. It is not seeking to reinstate CPP.
Point. I just wonder, maybe I'm just curious about it. How can an agency get rid of a rule it doesn't want if it doesn't want to go through a big rulemaking in order to get rid of it because it wants to do something else?
Well, I think to the extent that you put your finger on it, that's a really good reason why the DC Circuit didn't reinstate the CPP. And I should emphasize, no one was advocating to have the CPP put back into effect for all of the facts that I identified for Justice Thomas. Here, when we filed the motion for a partial stay, the other parties consented to that. And we were on record making clear in the DC Circuit that if ACE were invalidated, EPA was going to conduct a new rulemaking. That's exactly what it's doing, and so no federal regulation is in place.
Well, before the DC Circuit ruled, ACE was on the books, and they liked it. After they ruled, ACE was off the books, and you don't like that. Well, I don't understand why that's not fully justiciable.
Well, it's certainly true that they liked the legal analysis in the ACE rule, but I think the...
We'll hear argument.
Okay. Okay, what you can do is put it face up here, and you can do more than one at a time. You might want to straighten them folds a little bit. That one we'll have to do by itself. Just one copy of each page. Here's the copies. These are the original. Oh, did you need both sides? Oh, okay. Okay, there's the back side of it. Do you have any back sides you need to do? Here's the copies. These are your originals. All of these?
Yes.
Okay. Yeah. Do you need the back sides on this one too? Okay. Okay, here's a copy. Oh, one more copy. This is the originals. This one? Okay. Original. Next copy. Okay, the back one-sided. Okay. Original copy. Both sides. Here's the copies. And the original. And one side, okay. Now, here's one. That's the first one.
It's on number 1.
Oh, there. copy, and this one tore, it was stuck in the top. So those two go together. Those two, okay. Do you need both sides of this one? Yes. Okay.
Veterans.
Almost fails. Here's set in front. Okay, is that everything? Yes. Okay, $2.20.
With the highest amount. The highest line as the Google source and beyond.
Do you need a COVID test book thing?
We'll hear argument this morning in case 2015-30, West Virginia versus the Environmental Protection Agency and the
Justice, and may it please the court. The Clean Air Act, Congress directed EPA to partner with the states to regulate on a source-specific level, which means identifying measures particular buildings can take to reduce their own emissions. The DC Circuit gave EPA a broader power to reshape the nation's energy sector for most any other industry for that matter by choosing which sources should exist at all and setting standards to make it happen. Rules of statutory construction support that resolve. First, electricity generation is a pervasive and essential aspect of modern life and squarely within the state's traditional zone. Yet EPA can now regulate in ways that cost billions